Cross-examination attacks can continue with attempts to call into question the entire factual basis of your investigation. They may claim that your facts were inadequate, and they may even seek your support by asking questions that suggest other steps that you may have missed or other procedures that you may have chosen not to include. You should stay confident of your work, but prepare to answer questions that suggest inadequacy. You should be prepared to explain what things you chose not to do and why. You should also be prepared to express confidently why the scope of your work was enough to lead you to your conclusions. An important tactic to realize is that you do not need absolute conclusions. You only need to express your best opinion based on the most probable scenario and to a reasonable degree of scientific or medical certainty. Good cross-examiners have a set of effective questions with which to attack the adequacy of expert witness investigations. When asked during cross-examination, it will be devastating if any of them hit home and can demonstrate either oversights or weaknesses in your work effort. I discussed several of these types of questions in Lesson 9. If you do not recall those, you can review them in the section of Lesson 9 entitled Questions Meant to Attack the Factual Basis of Your Testimony. You may fall prey to such questions because your attorney or his client told you it was unnecessary to do such and such, or that they did not want to spend the money for you to do so and so. You might not have been permitted to run additional tests. You might not have been allowed to complete certain site reviews. You may not have been authorized to create reconstructions of certain events. You may have the best intentions, but from time to time you may be subjected to limitations as an expert witness that restrict what you can do or say. You will have to discuss that with your attorney. You may need to prepare explanations. You might dismiss the omission as unimportant or as something that you chose not to do because it was not necessary. If any of those activities that you did not do were necessary, then you may no longer be able to express the opinion you expressed. Let's talk about the technique called learned treatises to uncover contradictions. Attorneys will look for contradictions in your testimony that may appear in textbooks that are authoritative in your expertise area. They may use journal publications that are respected and professional, as well as published articles by other recognized experts in your field. This approach to undermining your testimony is called the learned treatise technique. This technique relies first on establishing a published work as a reliable authority. If that is done by your admission, then any relevant portions of that work can be read into the record as substantive evidence. Two things could constitute your own admission. You may admit during questioning that the publication is a reliable authority. Or you may have quoted from or referred in your earlier testimony to a passage from that publication. This means that other sections from your so-called authoritative text can now potentially be used to contradict your testimony or support the opposing expert's testimony. Either way, you need to be up to date on your readings of learned treatises in your field. You should have done your own research before trial to see what others may have written about the subject in which you are testifying. As a tactic, then, you should almost always refuse to validate any other expert or publication as authoritative in your field. If the opposing attorney asks you to confirm for him that a particular author, publication, book, or other expert is an authority in your field, only say yes if you know everything ever written or spoken by that authority. Otherwise, hedge your answer with an honest statement of either the usefulness of the publication or of your unfamiliarity with a particular work or expert. If you blindly say yes, the next thing you'll probably hear is the attorney reading a quotation from that publication that contradicts your own testimony. You then will have just lent authority to it by admitting in advance that the publication or the writer is an authority. At other times, you may be the expert whose writings are actually quoted to undermine your own opinion in the case. Now, if you have written articles or books that speak to the same subject as this case, you should be aware of any earlier statements in writing that contradict current statements or positions that you are taking in this case. If discrepancies or contradictions appear now, you should have an explanation prepared for the differences. And the same is true if you have testified in any earlier cases in which your deposition or trial testimony is a matter of public record. You will have to explain any previous statements that may run counter to current opinions if they are discovered and brought up to you during the trial. You ought to know if this is possible based on your earlier work, and you should have some good answers ready. As a valid explanation, for example, the facts referred to in a previous publication or a previous case could be different from the facts in this particular case. Also, the state of knowledge in your discipline may have expanded since the previous publication or the previous case. Current opinions may now run contrary to earlier industry opinions because of this new and greater knowledge. Now, some of you as experts will know that your own field of expertise may not yet be very well recognized. Your particular field may be new. Both relevance and reliability are part of Daubert considerations that are used to determine whether your proffered testimony and opinions will be admitted into evidence. Computer forensics, for example, was not even a field with a name in 1990. DNA analysis was not a recognized field of expertise in the mid-20th century. In both situations, these fields developed recognition and credibility over a period of years. If you testify in a trial in such a field, you can help assure the admissibility of your own testimony. You should come to court with information about any growing recognition of your professional field and about any learned treatises that others may have written that substantiate the viability of the field itself. Doing research about other court cases that may have used experts in your field would help further. Using the internet for such research is a perfect example of a field of expertise that did not even exist a few short decades ago. If your field does not have an academic degree that is obtainable, or professional associations available to you, or even certifications, that will not necessarily stop you from bringing in your particular expertise and experience to offer opinions and present testimony. However, this particular attack is one that you should carefully discuss with your own attorney. To take the wind out of the cross-examining attorney's sails, he may well want to address this particular weakness in advance during direct testimony. An additional ploy used to attack your particular field of expertise is to quote writers that are well known, but whose theses or science may be out of date. Some lawyers call this the hysteric gambit. Attacks on your particular sphere of scientific expertise can come from quotations taken from Galileo's writings that may be out of date scientifically, or references to unsubstantiated 21st century researchers. Your best defense in both cases is simply to know the history of your profession as well as the current state of its research.